dream I know, deep up my feelings for you. Watch.
Hello viewers, welcome back to this channel. Thank you all so much for joining us. The headlines: Mr. Daniel Biwa, the constitutional lawyer, serves as the spokesman to Atiku Abubakar in the 2023 election campaign, said that he's waiting to watch Supreme Court and Appeal Court fights. So guys, before we proceed with this news, welcome to Reality Latest Juice, your home of news and politics. Thank you all so much for joining us on today's news. If this is your first time of watching, please do us a favor to like and subscribe and also share. Don't forget to do notification bell to get notified when next we drop a video. You can send in your comments and keep the conversation lively in our comment section. To all our amazing subscribers, thank you all so much for joining us. To all our viewers, feel relaxed, enjoy and stay connected. In an interview monitored on Arise Television, Mr. Daniel brings his perspective on the unfolding constitutional questions arising from the conflicting judgments of the Court of Appeal in certain jurisdictions across the country. He particularly brings to bear the intriguing question of how the Supreme Court will approach the settled law on pre-election matters that were reopened by the Court of Appeal in Plateau State. In 2023 election, we have had the worst of the judgments of courts. We have not had so much of conflicting decision by one type of government, because if we look at the election tribunals this year, we will notice that there were inconsistencies in one or two tribunal cases at the trial level and at the Supreme Court. Probably one or two compliance. But at the Court of Appeal is where almost all these conflicting judgments have been experienced. For the record, the Court of Appeal is one court. So even if it were in Maiduguri at the Court of Appeal, it can still be relied upon the Court of Appeal in Lagos, because it is the same court. The court is one, and the court should be appraised of the various judgments they deliver and be consistent in the judgments, especially when the judgments are founded on the principle of law. Facts can differ, but the principle of law is constant, and wherever you turn, when the principle falls on a direction, the judgment has to be consistent and constant. But we can now see currently what is happening, the conflicting decision of the Court of Appeal, especially where they affect the People Democratic Party (PDP). There was the judgment of the Court of Appeal in Plateau State that removed the governor, and the appellate court dived into the merits of a pre-election matter, and they said that it's also qualified as a main election matter and delivered a judgment. The same Court of Appeal in Ebonyi State, the same pre-election was canvassed. The Court of Appeal in Ebonyi State said that it is a pre-election matter and they cannot dive into pre-election. In Benue State, pre-election matters was also raised in terms of forgery. The court in Benue State said that it is a pre-election matter and they are guided by the judgment of the Supreme Court. My people, this court, we can't wait to see the outcome where they are heading to. Because the supremacy of the judgment of the Supreme Court on pre-election matters, this is where the concern comes. Honestly, Section 287 of the Constitution of Nigeria makes it clear that the position of stare decisive and judicial precedence that the judgment of the Supreme Court is binding throughout Nigeria on all authorities and on courts that are subordinate to it. In this 2023 election, the Supreme Court of Nigeria settled the issue of pre-election matters brought by APM, in the case brought by APC, and in the case brought by Labour, where pre-election matters were canvassed and they were joined together with fundamental provisions of the Constitution to suggest that this is so germane that we cannot close our eyes from it. But the Supreme Court made pronouncements, in fact with anger and vehemence, that anybody who is not a member of a political party, and even if you are a member of a political party and where the issue borders on pre-election, it cannot be brought, and that can be tagged that they are doing too much. People say in 2019 that in Yari's case, the Supreme Court sacked APC, and that is why PDP is crying. But they failed to realize that in 2019, apart from the fact that it was a decision decided on the old order on both the amendment of the Constitution and the Electoral Act, it was a case brought by a member of All Progressive Congress, APC. It was an intra-party matter. But in this year, the Supreme Court said they are doing too much by trying to question if where the legality of what they are challenging is genuine. If they are not a member of the party. The issue on Plateau State, you all can see that there is no disobedience as a ground. Even in Plateau, where they said that there was no valid Congress, that they didn't even have a structure that will warrant for them to sponsor a candidate. What is the structure of a party as recognized by law? I'm asking. The National Working Committee is the soul and spirit of a political party. When you sue a party, you are suing the National Working Committee. Even if there is no any structure at all in a state, it cannot give a rise to decision of a court that there is no conduct of Congress. Even the order they claim was violated, the order was obeyed. In election tribunal, if the time passes you, even the Supreme Court said they cannot exercise jurisdiction. The character of pre-election matter, no matter the gamut in which it rises, can never be entertained by an election tribunal or an appellate court. Justice Nikki Toby and the various justices of the Supreme Court that have served and have retired always in their judgments always decide that any decision by the court lower than them that tends to run away from their decision is judicial rascality, because they are embarking on a frolic of their own. We also cited an example in the constitution we have today in section 287 that the judgment of the Supreme Court binds all courts in Nigeria that are subordinate to it. And in this case, it is the judgment of the Supreme Court that pre-election matters can be determined by an election tribunal. Plateau State has an interesting case for the Supreme Court. Our hope now lies on how they would interpret the case. This case of Plateau State, when it gets to the Supreme Court, it will be the case of Supreme Court versus Court of Appeal. It has more to do with the sanctity and integrity of that Supreme Court itself, because the Supreme Court will have to determine whether that judgment they deliver in presidential election tribunal is to be carried out by the subordinate courts in Nigeria. They made it clear that a decision by a final court is called a settled law. Once a case is not determined by the final court, it is not a settled law. But once it is determined by a final court, it is cast on stone. So the Supreme Court will have to determine whether the Court of Appeal is above it or it is above the Court of Appeal. So guys, let me know your thoughts, your contributions, your opinions are in the comment section. We'd love to hear from you. Let's keep the conversation lively in our comment section. Once again, thank you all so much for staying tuned with us. We really do appreciate. But if you haven't subscribed to our YouTube page yet, please do us a favor to like and subscribe and also share. Don't forget to turn the notification bell to get notified when next we drop our video, because I'm sure you don't want to miss out the trend and latest news happening on social media. On this note, we have come to the end of today's segment. Till I come here when next, stay safe guys. Bye.